Thanks very much, Stephen, for the introduction, and thank you to those of you who've come out at a very inconvenient time of day, at a very inconvenient point of Lent term, so I appreciate you giving up your time. As Stephen said, this isn't a classical private law paper, so it's probably a bit different from the stuff that's been in the series so far, but I hope you'll find it refreshing rather than irrelevant. I hope that'll be a positive rather than a negative. Just to give a bit of background, with the exception of Adrian, who I know is a corporate lawyer, is anyone else here familiar with corporate or company law, however you define it? Yeah, there's a few nods. That's good, encouraging. So I don't need to say too much by way of background, but I think it's fair to say that amongst the community of corporate or company lawyers, generally speaking, there's not been a great degree of concern about issues such as social inequality, distributive justice. These criteria haven't really been seen as within the corporate lawyer's mindset, and I'm thinking here of academic corporate lawyers. I expect the same would go for practitioners as well, but certainly amongst academics, it's not been, I don't think, a great, pervasive concern by any means. And corporate law debates and scholarship, particularly within the Anglo-American environment, the UK and the US, and to some extent other English-speaking Commonwealth countries, former Commonwealth countries, there is this still a sense that corporate law is either a doctrinal subject or it's a subject that should be studied principally through the lens of law and economics. So issues like efficiency, wealth maximisation should be the predominant normative concerns. Things like fairness, distributive justice aren't really relevant within that particular mindset. And I think it's fair to say there's a few limited exceptions, but I think that's a fair survey of the scene. And for the last 3 decades or so, as economic thinking has become more and more ingrained within corporate law scholarship, there is a quite heavily influential paradigm descended from the United States called agency theory, or sometimes the principal agent paradigm. And the notion is that we think of a company's senior managers as effective agents of its shareholders. Legally, that's not quite accurate, but analytically, it makes sense, some might say. So we view the senior managers of a corporation, of a public corporation, as being effective agents of the shareholders. And the core principal task of corporate law and corporate governance more generally, is to put appropriate incentives in place to try and ensure that managers are motivated at all times to serve shareholders' best interests, with shareholders' best interests normally being encapsulated in the idea of shareholder wealth maximisation, or shareholder value maximisation, however we refer to it. So the role of the law and, if I could say, incentive structures more broadly, whether legal incentives or broader market incentives, the role of these incentives is to try and ensure that, managers are motivated to be generating value for shareholders on a consistent basis. Some incentives could be negative, such as the fear of being fired if financial returns are not acceptable, the fear of the company becoming subject to a hostile takeover if its share price is depressed excessively in the market. And some other incentives will be positive incentives. So if the company's especially profitable for any period, managers can reap greater personal returns through performance-linked remuneration or pay. And this is where pay comes into the picture. Pay is an incentive mechanism to try and resolve or mitigate this so-called agency problem. Managers need incentives to serve shareholders' best interests, because without those incentives, they would be inclined to put themselves first, and shareholders therefore would suffer as a result. And that's basically the principal agent, or the agency rationale for performance-related pay, a way of trying to link managers' incentives to shareholders' interests. This is the theoretical blueprint, and in a way it helps to explain what happens in practice quite well, because in practice performance-related pay for managers linked to a company's stock market performance, notably its share price, is very common in practice within public companies. Things like shares or executive stock options. Other more novel schemes like deferred share grants or bonus schemes based on a company's periodic earnings or share price. All of these types of remuneration in various sophisticated forms are very pervasive in public companies now and have been for quite a long time. Now, it's common knowledge that performance pay has encouraged a progressive increase or ratcheting up of managerial or executive pay, certainly over recent decades. But this material increase in absolute returns of managers, and also the inequality that's resulted from that, is from this conventional agency, principal agent mindset. This is seen as not really something we should be overly worried about. If anything, it's actually a benign byproduct of effective corporate governance and action. If certain CEOs are making what many people believe to be perverse or exorbitant amounts of money from their job, it's because they're doing the job well. It's because the market's rewarding them, and therefore that's something we should celebrate, not necessarily something that we should castigate. And that's the standard principal agent way of looking at it. Now, the idea of pay for performance, the idea of linking managers' pay to shareholder return, stock market performance, is also something that's permeated quite heavily into the regulatory machinery, and this is where the law comes in a way. Although in corporate governance we often don't talk so much about law, we talk about regulation, because many aspects of corporate governance aren't in formal legislative form. So, for example, the Greenbury report, which was the kind of expert report, which really laid the foundation stone for modern regulatory policy on executive pay control in the UK back in 1995, made the point, and I quote, "The key to encouraging enhanced performance by directors lies in remuneration packages which link rewards to performance by both company and individual, and align the interests of directors and shareholders in promoting the company's progress." So it's this idea of incentive alignment, providing motivation for enhanced performance in shareholders' interest. And it's very much in line with this principal agent paradigm that I mentioned. And even in more recent regulatory developments in the UK, the most recent edition of the UK Corporate Governance Code and recent government policy publications again emphasise this idea about pay for performance, incentive alignment. These ideas very much have infiltrated into policy making at ground level. Now, it's common knowledge, and I don't need to spend too much time going over this, that executive pay has very much exploded over recent decades, certainly over the past 3 decades, with the United Kingdom and United States standing out as particularly notable examples. Executive pay has exploded in absolute terms. Senior executives of public companies, at least within the very biggest public companies, for example, at FTSE 100 or Fortune 500 level, they're earning more money, even in real terms, than they were, say, 30 years ago. They're also earning more money relative to average or median workers within the same firms. This has been very widely reported. I don't need to say a great deal about that. A few facts and figures, which are in the paper if anyone kind of browsed over it. In the UK, over the past 3 decades, annual FTSE 100 CEO pay has increased from £115,000 in 1980 to £4.3 million in 2012, which was the last figure I got. The ratio of CEO to average worker pay over the same period has increased by 900%, from 18 to 1 in 1980 against an average worker salary of £6,500 to 162 to 1 in 2012 against an average salary of £26,500. So it just gives you some idea of the scale of change. The US figures are even more eye-opening in that regard. I won't go through them in great detail, but from 1978 to 2012, average total CEO pay, including realised stock options, which is often the biggest component of CEO pay in modern times, average total CEO pay in the top 350 US companies by sales increased by 875%, so almost 9 times in that period. Average non-supervisory private sector worker pay in the US rose by only 5.7% over the same period. So that just gives you a kind of crude idea of the sort of figures, the sort of scale we're looking at. And there's been a number of criticisms, not just about pay inequality, but about socioeconomic inequality more broadly. And I don't want to go too down this track. A few choice quotes which I can pick out, which kind of raised eyebrows. The economist Thomas Piketty, who wrote possibly the best-selling popular economics book in 2014, Capital in the 21st Century, has called Britain Europe's most inegalitarian country. Joseph Stiglitz has said 30 years ago inequality in Britain was just average for the advanced industrial countries. Now it's second only to the United States. And even Simon Walker, head of the Institute of Directors, which is an organisation that's traditionally been perceived as being at the vanguard of the British business establishment, has said executive pay growth has lost any sense of relationship with the real world that normal people live in, and business leaders are now seen as aliens. And there've been lots of other kind of choice speeches, publications in popular parlance that further emphasise these themes, and I won't go through them anymore. We get the general picture. I think people are unhappy about inequality, and in particular, they're unhappy about inequality of pay, particularly within large private sector organisations. Now, how has the law responded? The law has not been oblivious to these developments, and we have seen a limited but nonetheless quite conspicuous change in the regulatory picture over recent years, both domestically and internationally. And we have seen regulatory developments to control executive pay that actually don't really seem to be quite consistent with this pay for performance paradigm. Performance incentive alignment doesn't really seem to be a valid rationale to explain some of the more recent regulatory developments that we've seen. Classic example of a recent regulatory development that seems to go beyond the orthodox view is the well-known EU banker bonus cap, as it's called, which was introduced in 2013 under CRD4 at EU level, which basically, we're probably aware of this, provides, subject to limited exceptions, that annual variable remuneration, including bonus, of a senior banking company executive cannot exceed 100% of that person's annual fixed salary. There are limited exceptions where shareholders can give approval to raise the amount somewhat, but as a basic baseline rule, variable remuneration cannot exceed 100% of fixed salary, the intention being to curb the former common practice where banking executives received bonuses or variable pay through stock options, which were many times, sometimes many times in excess of their base fixed pay. We've seen other notable and quite controversial regulatory developments in other areas as well. We've seen the imposition of rigid bonus bands and salary caps on employees of publicly rescued banks in some countries. Germany and the United States stand out as notable examples, where there's a €500,000 or $500,000, respectively, salary cap placed on employees of publicly rescued banks. We've also seen another quite controversial development in the United States in recent years, which was actually what motivated my thinking and reading on this topic last year, which was something called pay ratio disclosure, which is an SEC rule which was proposed under delegated legislative power from the Dodd-Frank Act. And the SEC, under this particular provision of Dodd-Frank, was given power to introduce something called pay ratio disclosure. And the SEC invoked that rule in 2013, I think it was, by developing a proposed rule. Pay ratio disclosure is basically a mandatory regulatory requirement at federal level in the US, requiring that a listed company discloses the ratio between, on the one hand, its CEO's annual pay, and on the other hand, its median workers' pay. Not its average worker pay, but its median worker pay. And the idea being to try and get some sort of sense within individual companies of the disparity at the top and crudely in the middle. And the UK, we haven't gone quite as far. That SEC rule, incidentally, has not been implemented yet. And it may not be for a reason I'll explain in a moment. In the UK, we've not gone quite so far as the SEC in the US, but we do have a kind of watered-down version of that rule in force now since 2013. In the large and medium-sized companies and groups, accounts and reports amendment regulations in the UK introduced a particular provision whereby quoted companies should disclose the annual percentage variation in CEO and average worker pay within individual firms. So it's not absolute levels of pay at each level that should be disclosed, but rather it's the year-on-year variation. So at least, in theory, employees can get some sort of sense of what the trajectory of pay increase or decrease is between these two levels. So in a way it does roughly crudely the same thing as the SEC rule in the US. And also there's a requirement in the UK now that in setting directors' remuneration policy, a remuneration committee which makes recommendations to the board on pay, the committee must be sensitive to pay and conditions elsewhere in the company when setting senior executive pay. So these have been, in some quarters, there have been much welcomed regulatory reforms. In other quarters, there's been much more unease and hostility about these reforms, as I'll explain in a moment. But one point, obviously, to emphasise is they are not in line with the standard pay for performance paradigm. Motivating senior executives to generate value for shareholders doesn't really seem to explain these reforms. There's something else at play. Broader considerations of social justice, distributed fairness, however we define it, do seem to be filtering into the picture. But there has been opposition domestically and internationally, and we've seen a number of criticisms being launched against these reforms. Particularly the EU banker bonus cap has been criticised for its, rigidity and its administrative impracticability. Particularly because many people in practice have argued that if we restrict the variable remuneration of bankers to 100% of their fixed pay, then naturally banks will just increase fixed pay as a way of rewarding bankers and retaining who they see as their star rainmakers. And as a result, we will have similar levels of pay with much less flexibility, much less performance sensitivity, and therefore more rewards for failure. And I don't dispute that's certainly a consideration. Also, criticism about compliance costs, especially in the United States, with the pay ratio disclosure proposed rule, because determining median pay, it's group-wide level, it's not individual company-wide level. So if we've got a corporate group with literally hundreds of subsidiaries in various parts of the world, with different wage systems, with different costs of living, there could be outsourcing involved. Determining the boundaries of the firm can be very different in these situations. There's huge practical difficulties about trying to determine median employee pay within that situation, and it can be hugely costly, as many people have argued. The old argument, senior executive positions will become less attractive. Everyone will go to Switzerland or Singapore. Maybe not Switzerland, because they've been quite active about pay disparity. Maybe stick to Singapore. But there is that old executive flight argument. But at the heart of these concerns, there is this view that pay equity regulation is cost ineffective. Economically, it doesn't really make much sense. And there's a common perception that equitable or fairness factors lie outside of core corporate performance concerns. It's not something that the rational investor really wants to know about. Maybe certain peripheral, socially, ethically aware investors might want to know about these things, but broadly speaking, it's not really something that's a concern of core corporate governance. In the United States, a notable development recently, in response to the SEC's proposed pay ratio disclosure rule, a Republican congressman called Bill Huizenga has recently introduced a further bill before Congress, which is called the Burdensome Data Collection Relief Act. And the sole purpose, you can kind of get the gist from the name, it doesn't really leave much to the imagination. Burdensome Data Collection Relief Act, and it's the sole purpose. I think it's one section long. The sole purpose of this particular bill is to get rid of the pay ratio disclosure rule, basically by amending the Dodd-Frank Act to take away the SEC's delegated lawmaking power, which would effectively render that reform dead in the water. At the moment, we don't know who's going to win this battle. It's a battle of the bills in a way in Congress. I think the odds are probably on pay ratio disclosure to survive, but it's by no means a done deal at the moment. So there's been a lot of hostility to these reforms. There's been quite a lot of support for them as well, of course, depending on people's position. But they certainly do challenge the orthodoxy. And certainly by orthodoxy, I mean the academic orthodoxy, at least within classic Anglo-American corporate governance. Now, within corporate law and financial economics, two very different thought disciplines, but who converge in certain respects when it comes to the normative position. And the normative orthodoxy within these two disciplines, at least in recent decades, is quite well summed up in a quote from the financial economists Michael Jensen and Kevin Murphy from 1990, a title of an article they wrote which was called "It's not about how much you pay, but how." It's not about how much you pay, the amount you pay. It's about the forms you pay people in and how sensitive they are to performance, how good they are at motivating them to do a job. If that means they get paid a lot, so be it. And from this point of view, corporate governance is viewed as a functional problem. It's a problem that needs solved. It's a problem of incentive alignment between shareholder principals and managerial agents. And performance remuneration is, to use an economic term, it's a contractual gap-filling device. The point is, shareholders cannot write fully watertight, 100% comprehensive contracts with directors or managers specifying what they should do in every situation. They need to trust them, they need to leave them to their own devices and give them discretion to do the job as they best see fit. But they need some assurance to give them peace of mind that they can vest that power in these officers. And one thing that gives them peace of mind is performance-related remuneration, because it means that regardless of how broad a mandate you give to the agents, you can at least trust that they're going to resolve their discretion in your best interest, because it's in their best interest to do so. And that's the contractual gap-filling explanation for why we have performance-related pay. And in recent years, there's been two, within corporate law and financial economics, they've crossed over a bit. There's been two dominant schools of thought when it comes to performance-related pay. On the one hand, there's what's been called the managerial power hypothesis. And this is associated most notably with Lucian Bebchuk and Jesse Fried from Harvard Law School. And people at Bebchuk and Fried would argue that CEOs of public companies have got soft power, in effect, to influence how much they get paid. They have de facto control over their boards, as they see them, their boards. And they have de facto control over remuneration committees, because other directors at board or committee levels see themselves as in some way being beholden to the CEO for their continued tenure in the company. And therefore, the CEO in effect wields this soft influence, but considerable soft influence over fellow directors. And therefore, other directors try to placate the CEO by providing them with fairly generous but by agreeing to fairly generous remuneration packages. And often Bebchuk and Fried would argue this explains why we see lax designed performance-related remuneration contracts. So, for example, we may see stock options which enable CEOs to benefit from market triggered rises in a company share price. So if it's a bull market and the FTSE 100 or Fortune 500 index has gone through the roof, the company might not be any more successful, it might not have performed any better at its business level, but nonetheless managers are going to be richer because of the general market rise, which would be called an unearned windfall. They would also argue that lax stock option programs can, for example, they can enable CEOs to cash out their options prematurely. So if a company has benefited from recent market performance, that the market index has gone up, they've made an unearned windfall, they can have the free power to cash out their options, to liquidate those gains, and therefore if stock price subsequently plummeted, the managers would have locked up their money in their bank account and that would be untouched, and therefore that's another way in which they could make an unearned gain in effect. And these commentators have argued that this was a particularly prevalent practice in some of the US investment banks that collapsed or were bailed out in the financial crisis, Lehman and Bear Stearns in particular. So that's the managerial power hypothesis. There's another school of thought which is called the optimal contracting hypothesis. This is associated mainly with Michael Jensen and Kevin Murphy from Harvard Business School, also Stephen Kaplan from University of Chicago Business School, and Stephen Bainbridge from UCLA Law School are particularly prominent names within this latter school of thought. The optimal contracting school says almost the opposite to the managerial power hypothesis. It says that at the end of the day, the sheer amounts that CEOs earn absolutely are relative to other workers is not a cause of concern, because as I said earlier, it's the view that this is the market at work. This is a reflection of these officers' worth and value to the corporation, and ultimately relative to the amount of overall shareholder value that a successful CEO can generate. This is just spare change, really, the amount of money that they're getting. It's insignificant, and in any event, it doesn't go markedly out of line with corresponding rates of pay for other high-paid individuals, for other successful individuals in other areas of life. It's just that CEOs are a particular target of political outrage, unjustifiably so. And in any event, the sorts of things that people like Bebchuk and Fried argue happen in an effectively functioning capital market, these things wouldn't happen. Because if managers were being paid too much, if they were not being properly incentivised to do their job, the company would ultimately suffer. It would be driven out of the market, its stock price would be reduced, it would be subject to possible takeover, etc., etc. Therefore, these things just don't happen. Or if they do happen, they happen to an insignificant extent. Now, these two schools of thought say two very different things, but one thing that's not really been remarked on is the commonalities that they actually share, because both the managerial power and the optimal contracting hypotheses both proceed from the same basic premise, which is that the sole motivating objective of pay setting, pay design, pay control should be aligning pay with financial performance. They just differ in how you get there. The managerial power people say we need structural change. We need either regulation or at least activist shareholder control to try and change established prevailing pay practices. Whereas the optimal contracting people say, no, what we've got just now is pretty much the best outcome we can hope for, and let's not mess that up. But although they both claim we're in a different place, they're both agreed on what we should be driving towards, and that's kind of where I would take a bit of an issue. Now, this pay for performance paradigm, if I can call it that, isn't intellectually sui generis. It's not out of keeping with ways of thinking in other areas of life. And in fact, its basic logic, I think, can be, in a way, I don't know if it traced back to, because I don't know if these people have read these authors, I presume they probably have, but certainly it bears some very strong parallels with the orthodox intellectual case against artificially determined pay equity. Some people might call this a neoliberal case because of the types of author who are normally associated with this view. But three of the most prominent thinkers who are referenced in the paper who have discussed the case against artificially determined fair pay from a kind of normative or moral political viewpoint, and also from an economic viewpoint, are Friedrich Hayek, Milton Friedman, and Richard Posner. And there's huge, dense reels of thought underlying this, but I'm not doing them justice at all. But for example, Hayek stressed in his classic liberal work that an individual's market evaluated performance should be central to determining the rewards that they're entitled to from any productive enterprise. Performance being how what they have done is judged by the market, as opposed to being judged by social, political or moral norms about how worthy someone's conduct is relative to someone else's. We might not regard a CEO as being a very socially or morally worthy individual relative to a NGO worker, or I can't think of anyone else, but a priest maybe, but depending on your view. But the point is, that's not a relevant consideration. Performance and worth as reflected in pay should be judged by the market, should be judged by what we want from that person, not what we think of them. A similar point made by Milton Friedman, who posited the idea that an individual should be able to appropriate the whole of what he called their marginal product. Therefore, I should be able to appropriate through my pay exactly what I add to University of Cambridge Law Faculty. That extra bit of value which I add, if anything, I should be able to appropriate the extra income streams accruing from in the form of student fees or whatever else that accrues from my contribution. I should be able to appropriate that in my pay. I should be able to appropriate no more than that, because then I would have an unearned windfall from Cambridge University, but I should also be able to appropriate no less than that. I should get my fair share as determined by the market. If individual pay does not conform to an individual's marginal product, then what happens? Those who get too much are disincentivised to work because they've got an unearned windfall. Whoever the person in Cambridge University whose pay is reduced to cover mine, they won't have the same incentive to work because they're not getting the same reward. And that's the notion of this idea of marginal product. Now, at its very root, the pay for performance paradigm that motivates corporate governance and to a large extent corporate law is premised on this idea. We should only be seeking to reward an individual's marginal product at any level, but particularly at the uppermost CEO level. And regulation or corporate governance control should help us to ensure that we're able to do that. Now, I should move quicker here. So, what's my sort of criticisms of that position? And I'm going to skim through them quite quickly, but I'm not really doing justice to my own arguments here. But in the paper, I make really three main strands of argument that I launch against this position. The first one is called the team production argument. Now, these are not my own arguments as such. The way they're pieced together is kind of my own product that I can take credit for. But the arguments themselves are well-established positions within the social sciences. It's just that they've not filtered into this mainstream legal debate yet. And one particular difficulty with this marginal product approach to executive pay setting is the notion of team production. And some of you may be familiar with the work of Alkian and Demsetz, who were one of the seminal modern law and economics thinkers in the United States, who made the point that where we have a team who are producing a product, like in a corporation, where a number of people are involved in producing something, and the thing that's produced at the end is a separate thing from the individual inputs, it's impossible to determine what any one of those individual players has done from the overall product. Now, the essence of coordinating production in the form of a firm is that we want to yield a greater output than the sum of our individual inputs. Otherwise, we wouldn't get together and work in a firm. But because you've got a different amount at the end of the day, because the thing that's been created, the output that's been created by the firm, as realised in the form of its profits, because that's usually more than, but it's certainly different from, the individual inputs, it's impossible to determine what each individual has done, absent close scrutiny of every individual worker in the team, which is usually practically impossible. So in this situation, we have something called a productivity metering problem. It's impossible to monitor individual productivity in any team situation beyond the most basic level of organisation. You can do it in a football team through pro-stat monitoring and things like that, but you can't do it in a public corporation generally. And this productivity metering problem is exacerbated in the case of what the economist Piketty calls supermanagers, corporate supermanagers, a category that includes CEOs. The notion being that in an assembly line where people are making widgets or screwing tops on toothpaste bottles, yeah, you can probably determine what an individual's contribution is with a degree of close monitoring. In the case of a public company CEO, because of the intangible nature of the job that they're doing, it's simply impossible to determine the value that a CEO adds to the organisation. In the same way, it would be impossible to determine how much value Brian or Sarah added to Cambridge University Law Faculty. They probably add a good amount of value, but how much that is and how we trace that is simply impossible because of the intangible nature and the complex nature of the job they do. And this is a problem particularly prominent with CEOs and other so-called super managers. So that's one issue that makes this line of thought difficult. And there is an argument that where it's impossible to determine individual workers' productivity, their productivity becomes determined, or at least is seen to be determined, by prevailing social norms, social views about the relative worth of individual and different types of worker. And in this regard, we could say a particularly prominent cultural norm in recent years has been, certainly in the United States, maybe less so in the UK, has been this idea of the so-called superstar CEO. The idea that by appointing a high-profile and skilled CEO, a company can initiate quite instant top-down change that can have profound effects, which is really quite a simplistic way of looking at a complex team production situation. And arguably that dominant way of thinking, perpetuated in the popular media, has led to CEOs perhaps being seen to be entitled to more than they actually are, than actually reflects their marginal product. Second, and speeding up even quicker, a second line of argument I would kind of launch against the orthodoxy is something which the very high-profile economists George Akerlof and Janet Yellen, one's a Nobel Prize winner, one's now head of the US Federal Reserve. Akerlof and Yellen call this the fair wage effort argument. This is an argument that some people have some sympathy with. I'm going to quote from their article. Workers have a conception of a fair wage, and so far as the actual wage is less than the fair wage, workers supply a corresponding fraction of normal effort. Akerlof and Yellen also developed something called the relative deprivation theory, which is people's conception of fairness are based on comparisons with salient others. So how much I earn and whether it's fair is determined partly by what I've got, but as much, if not more so, than by what my colleagues get, than by what other people get. And relative deprivation generates feelings of dissatisfaction, and empirical evidence has shown that that leads to worker unproductivity. So the argument there is sometimes what may be an optimal pay arrangement within a team production situation might be very different than what an optimal pay structure would look like if we just looked at individual workers and their respective levels of marginal product. And when we look at the corporation as a team as a whole, actually rewarding certain individuals less than their marginal product and other individuals more than their individual marginal product may in the face of it be economically inefficient, may in the face of it lead to under-reward of high earners and free riding by low earners. But actually, the fair wage effort argument would say that would be a perfectly rational strategy because it creates a greater salient sense of fairness, intersubjective fairness, rather than objective market-determined fairness. But nonetheless, that's ultimately what would be conducive to a more productive team situation. So that's just another flavour from that literature. And the third and final argument, before I conclude, is what's called the motivation crowding argument. And I'm skimming over these two quickly, really, to do them justice, because there's a huge amount of literature that lies behind them. The motivation crowding argument picks up on this idea of what social psychologists have called intrinsic motivation, which, to use Dekai's definition, is the motivation to perform an activity for no apparent reward except the activity itself. In other words, you don't need extrinsic rewards, pecuniary incentives, such as bonuses, to entice you or encourage you to do a good job, because you would do it anyway. And where we do provide direct extrinsic pecuniary awards to individuals for doing a job that they would be motivated to do well anyway, potentially negative economic results can come about. On the one hand, we may pay people incentives that actually they don't need because they would done a good job without. If Stephen had paid me £100 to come here tonight, I would have taken the money and said thank you very much, and I would have come along. Stephen didn't pay me £100 and I still came along because I want to come and speak to you. Cambridge University would have wasted £100. It would have incurred an agency cost of £100, which it didn't need to. Another problem is if Stephen had a common practice of paying £100 to everybody who came along to give a CPLC seminar, then we would start to expect it £100. We wouldn't come along if we weren't paid £100. Or if we weren't, we might not be inclined to put the same amount of work into preparation. In other words, our motivations would be crowded out by money. We would do a less good job. The organisation would be less productive. And thirdly, empirical evidence has established that where you do introduce pecuniary incentives into the mix within an organisation, where you crowd out individuals' intrinsic motivations to do a job, once those motivations have been crowded out or removed, the only way you can bring them back in is by promising significantly higher rewards. This is a point that the moral philosopher from Harvard University, Michael Sandel, noted in his book, The Moral Limits of Markets, where you remove intrinsic motivation, where you monetize or commoditize a particular service, then when individuals start thinking in terms of money, they normally want a serious reward to do a job that they maybe would have been willing to do anyway for the sake of it. And therefore we have an added agency cost. And in a way, one might say this arguably explains the common practice in investment banks in recent years of awarding quite what many people would say are lucrative bonuses to employees for meeting basic job targets, even where levels of performance were, by many people's estimations, unexceptional. This is summed up in a quote by Sir Philip Hampton, the RBS chairman, a couple of years ago. He said, "In my view, the whole process of incentivisation is overrated. Most business people don't get up in the morning thinking, I've got to do this today to get my bonus." Whether we agree to that or not, I'm not sure. When I gave this paper in London back in November, a city solicitor from quite a leading firm came up and said, actually, in his view, most of the bankers he advises do get up in the morning thinking, I've got to do this to get my bonus. So maybe that defeats the theory. So I've skimmed over these very quickly, but really what is my conclusion? And it's there has been this quite a large degree of hostility, less so in Europe, admittedly, more so in the United States, hostility against regulatory intrusion or interference as it's seen in executive pay setting, which is seen as giving rise to a lot of potentially negative consequences. As a result, there has been quite a strong strand of resistance to pay equity regulation. Things like bonus caps, pay ratio disclosures, these sorts of interventions. There's still a dominant way of thinking, particularly amongst academics, that where CEOs of public companies have got perverse or skewed incentives, where they don't seem to be subject to the right incentives, the solution to the problem is to tighten up performance pay, to make their pay more acutely sensitive to performance. And what the kind of sort of normative implication that follows from this paper is we should be a bit more, it's not a very profound or very sort of emphatic conclusion, but it's a word of warning and caution to say we should be a bit more sceptical about relying on pay for performance as a kind of panacea, a cure to all ills, not just within corporate governance, but also within broader organisational governance, even though that's outside the scope of my paper. Obviously, performance pay is something that has in recent years been implemented in different spheres of life, particularly in the UK, where it's now being quite explicitly rolled out across the National Health Service, amongst other organisations. The insights of this paper from these other bodies of thought suggest that in many respects, in many contexts, pay equity could be at least as likely to prove productive and net wealth increasing for an organisation than it would be wealth reducing, depending on the complex incentive patterns within the organisation and how performance-related remuneration impacts on the organisation, and there could be positive consequences, there could be negative consequences. Ultimately, performance pay could be completely futile as well in certain organisational contexts. So my argument is there have been certain schools, there have been certain voices in recent years which have said we should try to filter distributive justice or social fairness concerns more centrally into corporate governance, more centrally into executive pay determination. Now, that's not my argument directly, but certainly my kind of modest conclusion would be that that if we do regard that social justice, distributive justice case as being a valid one, morally or politically, then we should be a bit less uncomfortable about the purportedly adverse economic consequences that are likely to follow from controlling or even perhaps regulating pay on these grounds. And the idea of pay equity regulation or factoring fairness or equity concerns into executive pay generally, it may not be such a crazy, catastrophic idea as many seem to have made out. And in actual fact, there may be cause certainly to be a lot more ambivalent about the consequences of adopting such an approach. So that's my muted conclusion.
That was fascinating.